To put some context to the events that transpired in the Parliament last night. First of all, I propose to give you a timeline as to how we got to the Parliament last night, what we went there to do, and then the short particulars of what transpired, trying to be as factual as I can. The matter before the Parliament yesterday was the reintroduction of anti-gang legislation into this country. That was a bill before the Parliament. It comprised 18 clauses, 2 schedules. 4 of the 18 clauses were of no real consequence. Matters such as the short title, the act being inconsistent with the Constitution, and the amendment of the schedules. Very simple stuff. The other 14 clauses were replications with some necessary modifications to the old Anti-Gang Act number 10 of 2011. Those modifications that were made, in essence, were done specifically at the request of the Trinidad and Tobago Police Service. Secondly, following upon the successful operation of the anti-gang legislation equivalent in Jamaica, which was made law in 2014 and amended in 2017. And thirdly, born on the back of local jurisprudence in decisions of the High Court and the Court of Appeal in reflecting upon anti-gang law. As a matter of fact, so deep was the experience locally that the statistics in Trinidad and Tobago demonstrate that we have inactive pursuit in the courts of Trinidad and Tobago. There are 40 anti-gang matters in the High Court right now. We also have 33 matters on anti-gang in the magistracy. That is to be laid against the fact that there was also an interesting other form of background. You will remember that in the state of emergency, some 463 people were arrested for gang offences under the Anti-Gang Act, and the DPP took a step to enter and to give up on prosecuting 213 of those matters. So let me put that into a small summary statement. Notwithstanding the fact that the DPP let go of 213 matters in the Anti-Gang Act under the state of emergency, there are still active matters, 73 matters in total on the anti-gang law, and we have had judgments in the High Court and in the Court of Appeal speaking to the anti-gang law, and we have also had successful prosecution under the anti-gang law. So the anti-gang law, which expired on the 15th of August 2016, is a law which is, in many senses, one which operated well. The judicial reflections made, in particular by Mr. Justice Nolan Barrow of Appeal, were simply that the anti-gang legislation is no slam dunk. There must be a careful methodology to getting to the anti-gang position, but it can well work. There was no negative reflection by the judiciary that the law was unconstitutional, unoperable, nor was there any negative reflection by the DPP, simply because there's still 77 matters ongoing and there has been successful prosecution. Let's go to the timeline now. Trinidad and Tobago is aware that in 2011, the UNC government came to the country and said, let us bring forward anti-gang legislation. In fact, there was some draft anti-gang legislation at the Ministry of National Security. When they came in, the Ministry of National Security could not complete its exercise when the May 2010 election was called. In 2011, the UNC came forward with work which was in progress between the United States government and the Ministry of National Security on anti-gang positions. On the 16th of July 2010, the UNC introduced anti-gang laws into the Parliament for first reading in the House of Representatives. On the 1st of December 2010 and the 2nd of December, the House of Representatives referred that anti-gang legislation to a joint select committee. That is, let me repeat, 2010 July, 2010 December. On the 11th of March 2011, a Joint Select Committee produced a report. And that report was adopted. The committee report was debated on the 1st of April 2011. And then the 5th of April 2011, it went to the Senate. On the 12th of April 2011, the Senate passed the anti-gang law with amendments. And on the 16th of May 2011, those amendments went back to the House of Representatives. The work which was produced by the Joint Select Committee was work produced by the efforts of the opposition PNM, the UNC government, and the independent bench. There was a report confirming the 8 sittings that they had. In fact, I counted the number of hours. There were about 10 hours spent in committee, full stop, and amendments to the law were put forward. But that law was settled by way of a joint select process. We then noticed that the law as produced was settled in respect of the very matters that relate back now to what came in the bill, which was defeated last night. So for the record, that's the history of how the Anti-Gang 2011 law came up. Those are the steps which were taken. The draft which settled the law is there at the Parliament website for all to see, and the report of the committee is there for all to see. And you will see chapter and verse, all of the particulars that are dealt with there. On the 21st of August 2011, the country witnessed a state of emergency being declared. And it's important to note that the anti-gang law was assented to a couple of days prior, proclaimed only a couple of days prior. After the Senate amendments were accepted on the 16th of May 2011, the law was assented to on the 23rd of May 2011, and on the 15th of August 2011, the law was operationalized by the President, by the Cabinet, saying, please proclaim this law. And so Legal Notice 159 of 2011 was issued, and the law became law in Trinidad and Tobago. It was 6 days later, on the 21st of August 2011, that a state of emergency was put into effect. And the cases which I just referred you to, the 77 cases in the court system, the 231 cases that the Director of Public Prosecutions let go, all of those matters, the vast majority of them, arose in the state of emergency. And the 231 plus cases that the DPP threw out were on the back of the courts being told by the Director of Public Prosecutions, who has the sole power to let go of prosecutions pursuant to Section 90 of the Constitution, the DPP went and said, there is no evidence to sustain a charge, let these people go. In fact, in Trinidad and Tobago, the Office of the Attorney General has 45 matters right now concerning false imprisonment and malicious prosecution as a result of those matters. Several of them have been settled so far. There are 37 of them awaiting settlement right now. And on average, cases are being settled between $100,000 to $200,000. So, the cases which were gang-related cases, which went forward and which collapsed, came about, and as we heard last night from one of the members of Parliament, Mrs. Jennings Smith, who was a police officer at the time, the instructions coming from the then government was go out and arrest and find the evidence after. What we have found, 77 matters there's clear evidence for. There is prosecution of one successfully had, but I've just informed you that some 45 other matters are false imprisonment, malicious prosecution, and millions of dollars in damages to pay for. So, put that into the matrix, it means the anti-gang law as declared by our courts and as operationalized by the DPP and the police is good law. That's a fact. The 2011 law was good law. There's no judicial reflection that is negative. In fact, the courts took their time in the Court of Appeal by Mr. Justice Barrow to say how the law should be operationalized. The very important thing to put into the mix now is the steps that we took to come to the Parliament. Trinidad and Tobago knows that the People's National Movement came into office by winning an election on the 7th of September 2015. The government was formed on the 9th of September 2015. We, of course, became aware that there would be an expiry of the anti-gang legislation, and we also knew that there had to be significant steps to operationalize intelligence to make the law work, because the courts are telling you the law is good, you require intelligence, you require police structures. And the government of Trinidad and Tobago went about doing some very specific things to allow the anti-gang laws to work. Number one, we amended the SSA Act to broaden the definition away from a focus on drugs only and to include a definition of serious crime, which includes terrorism, money laundering, and most importantly, gang activity. Secondly, as you will be aware, we went into the Trinidad and Tobago Police Service, had audits done in successive stages, not just this famous manpower audit, but other work. And we had a reorganization of the Criminal Gang Intelligence Unit and the OCNFB, the Organized Crime Narcotics Firearms Bureau. And we encouraged a merger which came to life by an Organized Crime Intelligence Unit, which is now populated by 159 people, with a standing power of 400 people, which is being populated as we speak, go forward. So those are the two operational legs. Very importantly, we went to the Parliament on the 17th of June 2016, and we said to the Parliament, by way of our miscellaneous provisions, anti-gang and bail amendment, Bill 2016, we said to the Parliament, this law, this anti-gang law, and very importantly, the bail amendments which went along with the anti-gang law in 2011, they are about to come to an end on the 15th of August 2016. Please allow for an extension of time to 2 years to 2018. And I want to explain this very carefully. The anti-gang law in 2011 came forward with bail amendments side by side. The Joint Select Committee considered two bills, the anti-gang bill and the bail amendment bill. And the bail amendment bill specifically provided that persons who were arrested under the anti-gang law could not get bail if their matters started within 120 days. You were denied bail. The courts were put out of any discretion for bail. If your matter started before 120 days, no bail for you. If your matter was not completed within 1 year of it starting, well, then you could apply to a judge for bail. In coming to the Parliament in 2016, we asked for both to be extended, but we explained very carefully that we were doing the review on the legislation because the last government had done none. All of the statistical information that I've just explained to you was not available, there was no analysis, and there was no preparation for that sunset clause to come into effect. Understand that the UNC's passage and our cooperation as opposition in supporting the Anti-Gang Act gave the UNC 5 years, and that was a time of expiry after their political cycle. So we said to them, okay, 2011, 12, 13, 14, 15, the elections should have been held normally by May 2015, and we said to them, take August 2015 for the expiry. Run your full term. Go to the polls and let this country, let the law operate without regard to politics. That is what we said by giving a 5-year window for the review of the law by putting the sunset clause. When we came to the Parliament in 2016, on the 1st of July 2016, as the record will show, all 22 PNM members present voted yes. All 18 UNC members voted no. The law requires a 3/5 majority because of the detention provisions and because of the bail provisions. That's the old law that we were seeking to extend. And therefore, we required the opposition to say yes. And it was axiomatic. It was basic from our perspective that they would have said yes. Number one, because they didn't do the homework or research to say whether the law was working or not. Number two, we asked for a very short window until 2018 to do the review and come back to Parliament. The population knows the anti-gang extension failed. It was in the period 1st July 2016 to July 2017 that the PNM government went to work in bringing to life the SSA, in bringing to life the reformatted intelligence arm for gang activity under the Trinidad and Tobago Police Service. And it was in the period of time of this government that we saw eruptions in the Beetham Estate, in the Enterprise area, and we saw gang activity. The population is aware that on the end of November, just after the Beetham incident, on the 30th of November, if I'm not mistaken, I came as someone reporting before the media in my capacity as Attorney General, and I gave the nation statistics on gang activity, called a press conference, dealt with the gang activity, and laid out chapter and verse of the number of gangs and the positions in Trinidad and Tobago. In fact, we told the country specifically that there were 211 gangs and that there were 2,459 members of gangs. We introduced the concept that the Beetham activity related to gang activity. We made certain statements there, but very importantly, in the analysis of position of gang activity, the material used to give life to the 2011 version of anti-gang law, that's the UNC version of law, the figures were under 80 gangs and under 1,000 gang members. So in 2011, with under 80 gangs and under 1,000 gang members, anti-gang law was given to the country for the first time, because without this law, you can't treat with gang activity. You may be able to treat with individual offenses, but not gang activity. We came further and we said that in 2014, the statistics showed that we had 92 gangs and 1,500 members. And when you compare the position which we gave to the nation in November, saying that there were now 211 gangs and 2,459 known gang members, that represents a 129% increase on the 2014 figure and a 63% increase for gang membership on the 2014 figure. We came to the Parliament and we brought the Anti-Gang 2017 bill. As you know, that was introduced on the 1st of December, and we took the second reading and debate of the bill last night, the 5th of December. So we introduced on the 1st of December, right after the press conference. We then came to the Parliament. That's last Friday we introduced it, and this Wednesday past, yesterday, we debated the law. Very importantly, the anti-gang bill that we brought did not include any amendments to the Bail Act. Let me explain that. When, on the 1st of July 2016, the UNC opposition refused a 2-year period of extension so that the country could have reports on the operationality of anti-gang and bail amendments, the law collapsed with respect to bail. And the entire series of amendments, there were 11 amendments to the Bail Act. All of those amendments collapsed, and the law on bail went back down to 1994. 1994 is where the Bail Act returned. In coming to the Parliament on Friday for first reading of this bill, and yesterday to debate the bill, we did not change the bail laws as they now stand. We did not come to say incarcerate people for 120 days. If your trial is not started within 120 days, that you will get no bail. We did not come with that. And we did not come with excluding the judiciary from considering bail at all. We came squarely with the anti-gang laws. They are the 18 clauses that were produced for consumption and debate, 4 of them relating to title and small matters that don't affect the law, and 14 of them dealing with the provisions of the law. Very importantly, the provisions which we brought forward in the law treated with the ability of the Trinidad and Tobago Police Service and the benefit for the people of Trinidad and Tobago to have anyone who shoots at any gang member or gang activity which results in activities including shooting at police officers, prisons officers, Trinidad and Tobago Defense Force officers, customs officers, immigration officers, Board of Inland Revenue officers, all persons defined as law enforcement authority. If there was any retaliatory action to these people by gang activity, that they could be caught under the Anti-Gang Act. We also allowed in this bill for evidence, and it's at clause 5 of the bill, to be used in identifying gang activity, including the ability to go behind video evidence, the famous Rasta City videos, the famous ISIS videos. We allowed for the law to use the circumstantial evidence as evidence of gang activity. We allowed for the very novel introduction of anti-retaliatory terms. It's in clause 8 of the bill, where gang members who take activity against people who want to leave, or family members of citizens who live in areas that are savaged by gang activity, like Enterprise, like some parts of Trinidad and Tobago, otherwise including the Beetham, including San Fernando West, where I come from. We allowed for people taking retaliatory action against members of the public who took action against gang activity by saying, my son will not be a gang member, I'll not be put out of my home, I will not be driven out of my district. We allowed in this clause 8 for a fighting chance for the police to go and lock up the people and take them before the courts who were treating with these matters. We debated the bill. We started at 10 a.m. and the vote was taken at 12:54 a.m. on the 7th of the 12th. I write down clause by clause when the vote is taken. As each clause is taken in the House, I take notes, and we went through in the exercise of the committee stage last night, we went through all 18 clauses. We considered amendments offered by the opposition. There were 6 amendments. They proposed to amend the schedule. We agreed. They proposed to amend the manner in which the schedule can be amended. We agreed. They proposed a sunset clause. We agreed. They asked for clarification in relation to how warrant or non-warrant entry and search is done by the Trinidad and Tobago Police Service, which is at clause 15. They asked that every single exercise by the police be done by way of warrant. We listened to their points of view. We pointed out to them 2 very important things. We said, the lesser one of which is the first, we said, we accept that the law to treat with entry and search at clause 15, that's the powers of police officers, police powers of entry, search, and arrest. We accept that that is divided into 3 subclauses. We stated for the record that they were the exact clauses that the UNC brought to the Parliament in 2011. The power to arrest without warrant any person whom a police officer has reasonable cause to believe is a gang member or gang leader was the exact law in section 12 of the expired law. The police officer's ability to enter a home with a warrant was the exact law in section 12 of the old expired act, and the police officer's ability to enter without a warrant and search any place not used as a dwelling house was the exact law as it was in 2011. We pointed that out as the first point. But the second point as to why we could not agree upon an amendment that you must use a warrant for everything, we pointed out that under Chapter 1501, the Police Service Act, Sections 45 and Sections 46 in particular, the law is that a police officer can arrest and enter without a warrant anywhere. A private place, a public place, a office building, a dwelling house, anywhere. That's the law in Section 45 and Section 46. But because we agreed that there was merit in making sure that police could not enter homes without a warrant, we had to maintain the law as it was in 2011. So we had to be careful to specify in the statute no warrant for public place, no warrant for anywhere else, but you must have a warrant for a home. And that was a safeguard for the citizens, which the Joint Select Committee in 2011 agreed upon, and which the UNC had in law for 5 full years, and which we repeated, and they accepted. Very importantly, we took the vote on every single bill, clause by clause of the bill. Clause by clause we took the vote, because every clause is called first. In fact, we sought at the beginning, in the areas where there were no contention, to take them in groups. The chief whip said, no, 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 we want every clause done one by one. We said, no problems. Clause 1 to 18 were put to the vote in the committee stage. Clause 1 was passed at 11:33 p.m. No objections. Clause 2, 11:36 p.m. No objections. Clause 3 at 11:36 p.m. No objections. Clause 4 at 11:45 p.m. No objections. Clause 6 at 11:46 p.m. No objections. Clause 7 at 11:46 p.m. No objections. Clause 8 at 11:48 p.m. No objections. Clause 9 at 11:49 p.m. No objections. Clause 10 at 11:49 p.m. No objections. Clause 11 at 11:49 p.m. No objections. Clause 12 at 11:50 p.m. No objections. Clause 13 at 11:52 p.m. No objections. Clause 14 at 11:53 p.m. No objections. Clause 15 at 12:04 a.m. No objections. Clause 16 at 12:07 a.m. No objections. Clause 17 at 12:08 a.m. No objections. Clause 18 at 12:17 a.m. No objections. The schedule at 12:52 a.m. No objections. Not a single objection. The insertion of a new clause 19 at 12:17 p.m. No objections. Bit by bit, clause by clause, hour by hour, minute by minute, word by word, we went through the bill. We had fulsome discussions, and when the vote was put on clause by clause, there was not a voice opposite saying no. Not a single voice. Not Mrs. Prasad-Bissessar, and not any member of the UNC. In fact, there was a point in relation to Section 15 where Dr. Gopi Singh chimed in and said he had serious conscionable objections to the warrant issue. He gave a personal story. We asked him how it is he agreed to it when he was in government. He said collective responsibility, and he nearly left cabinet, but he still agreed. And when that vote was put, Dr. Gopi Singh was silent, did not say no. He said yes. The ayes had it. When we came to take the final vote on the passage, after the committee stage, the Attorney General stands up and says, we wish to report the bill to the House. I reported to the House that the bill was considered in a committee of the whole, and there were amendments made, and I asked for the third reading and passage. The Speaker then stands and says, this bill requires a 3/5 majority, and therefore a vote will be counted. It was at that point on the collection of voices, the collection of votes, one by one, the names are called in the Parliament. All 22 PNM members present, 21 PNM members present, because Minister Webster Roy had a personal difficulty with a family event. She had an incident which was of concern, and Maxi Coffey, as you know, was out on sick leave and is ill. All members present on the PNM bench voted yes. When we came to the vote to the opposition, it started with no. And it included, according to Dr. Gopi Singh, a big fat no. Suffice it to say, it was shell-shocking to see what happened yesterday. after 14 hours of work, which was more work than the entire Joint Select Committee's 10 hours that took the 8 sittings in 2011 under Anand Ramlogan. Very importantly, St. Augustine, Prakash Ramada, abstained and did not vote. But I'll tell you, as I now come to an end, leaving room for the Prime Minister, I saw the look on the faces of those opposite me last night. I saw shock. I saw fear. I saw disgust. I saw a member of the UNC bench have some very heated words with his leader and storm out the parliament. And I think I'll end on that note.